This is an appeal in Logix Aero Ireland Limited versus Siam Aero Repair Company Limited.
Yes, Mr. Page.
May it please your lordships and my lady, I appear for the appellant Logix. I'll refer to it as Logix. My learned friend is Lucy Coulter for the respondent Siam Aero. My lords and my lady, this is Logix's appeal with the permission of Lord Justice Males, and I'm assuming your lordships and my lady have read this Lord Justice.
We read pretty much the whole lot. So.
Yes, I'm sure. With the permission of Lord Justice Males, against the decision of Mrs. Justice Heather Williams striking out Logix's claim against Siam Aero, the only issue on which permission was sought was Logix's claim for damages for breach of a confidentiality clause in the letter of intent dated 4th of July 2024. The central issue in this appeal is whether it's arguable that inadvertent provision to a fraudster in breach of contract of a document including instructions for payment, which the fraudster could and did use to forge a payment instruction to himself, is actionable. The position taken by Siam is that the parties were equally deceived by the fraudster. If that's the case, justice might seem to suggest that the loss should be shared. However, I'm not aware of any mechanism for that outside settlement. There have been negotiations, but they have not been successful. The position today is therefore that either one party or the other should suffer the whole loss. And we say that party should arguably be Siam Aero, since the loss was effectively caused by its breach of contract. Siam has put in a respondent's notice, which raises a number of further issues, I think 4 in number. And I'm going to refer to them in the order that they are in Miss Coulter's skeleton. Ground 1, it said that it's not pleaded that Logix relied in releasing funds to the fraudster on the specific nature of the information contained in the 4 emails relied on in the draft amended particulars of claim. Your lordships may, my lady, may be aware that an amended particulars of claim was put before Mrs. Justice Heather Williams, though permission was not given. Because if the claim was going to be struck out, there's no
she
point.
acted as if it was your
that's
claim.
right. It was,
yes.
that was regarded as our claim. And it said in ground 2 that the emails were therefore not causative of Logix's payment to the fraudster. It's incorrect that Logix did not rely on the technical information provided in the mails. It did rely on the technical information, which could only have come from Siam Aero, as well as upon the signatures of the emails appearing to have come from Siam Aero in making its payments to the fraudster. We say this is obvious, but also implicit in paragraphs 12a and 15 of the current draft amended particulars of claim. But in order to leave no room for doubt, we have prepared a modified amended particulars of claim, which was circulated, I think, on Monday. I think your lordships have seen that. The reason we did that is because, as your lordships and my lady are aware, a claim can't be struck out if any defect in it can be cured by amendment. So I have prepared an amendment to deal with ground 1. As the judge found, both parties believed they were communicating with each other. Could I just refer your lordships to Miss Coulter's skeleton at core bundle page 45. Is it useful to refer to dividers or not? It's divider 4, page 45.
Thank you. Yes.
She says at paragraph 28, at the bottom, that the two sets of communications, which were in crucial ways mirror images of each other, enabling the fraudster to meet both parties' expectations as to what they ought to receive and when, and as what ought to be requested of them and when. And that I don't dissent from. And the details contained in the sale and purchase agreements of the engines and of the life limited parts were exactly what my clients expected to receive from Siam and could only have come from Siam. While we're on this page, could I just refer the court to the paragraph above 28, which is 27E. There's, I think, an unintentional error in that paragraph. It refers to signing a doctored LOI. I think Ms. Coulter must mean a doctored SPA. The LOI wasn't doctored. I think that's fairly obvious. But in any case, the key fact for this appeal is that the emails sent by Siam Aero to the fraudster contained the bank details for payment, and that enabled the fraudster to manipulate the details.
Just a moment.
If these emails had not been sent to the fraudster, Logix would not have, obviously, had not have paid out to the fraudster's bank account.
Providing Siam's bank account details to a third party can't possibly be a breach of a duty to you.
Sorry, we say that Siam's sending of the sale and purchase agreement was a breach of the confidentiality clause in the LOI.
Yes, but I thought you were referring specifically to bank account details. I mean, there's nothing to stop anyone providing their bank account details to anyone they like. Their own bank account details.
I think to supply your bank account details as part of a sale and purchase agreement, which itself is confidential, is prohibited by the LOI. The LOI doesn't just deal with confidential information, strictly so called. It covers every piece of information or document produced pursuant to the LOI. That's what the LOI.
Bank account details aren't produced pursuant to the LOI, are they? Every time you write a check, you give someone your bank account details.
Well, these contracts containing the bank details were produced under the LOI. Our case is that everything in the sale and purchase agreement was produced by the LOI.
Well, that means the parties,
under the LOI.
so the parties' names and their addresses and
Yes.
and their email addresses, which are publicly available.
I don't know about the email addresses being publicly available. Maybe they are.
But most of this information is people's bank account details are publicly available.
Yes, yes, my lord. But these were all produced to Logix and to the fraudster pursuant to the LOI. So they're all covered by the LOI. That's our case.
Yes. Well, it doesn't lose anything by clarity. I mean, it'll be a matter for us what we make of it, because as it seems to me, there are two possibilities: that this sad state of affairs was occasioned by correspondence between the parties, or this sad state of affairs was occasioned by a fraudster somehow getting into the system.
Yes.
And so, obviously, if you had been able to demonstrate that through having an incompetent internal electronic records keeping system, the defendants as they were had, as I might describe it, let the fox into the hen house, then I can quite see how you might have a number of causes of action against them. But the way, as I read it, the judge saw it, is that this wasn't the cause of the loss, that the fox was in the hen house. And that after that, yes, there were hens and they were communicating, but it wasn't the fact the hens were communicating, it was the fact that the fox had got in that was the problem. And you know, for any party that suffers loss as a result of that, one has no sympathy. But those are the competing arguments. You're asserting that it's the fact that the hens were clucking, but the case against you is that the fox had somehow got in, and it wasn't possible for the judge to say, and for anybody to say, how that had happened.
Yes, but my lord, the judge did find that there was a breach of the arguably a breach of the confidentiality clause, and the judge's findings were along the lines that your lordship has indicated. However, there is authority for the proposition that if in contract or tort, a breach of contract or a tort causes a loss, then it's no defence to say that the loss was equally caused by something else.
Yes, I understand.
And we rely on that. We'll be coming to that in the course of my submissions.
Could I just? Sorry, I don't want to hark on one particular point, but I think it's helpful in understanding what you say. The bank account details are set out in the SPA, and indeed in the LOI and in various places. Now, that is information that is in the documents.
Yes.
Are you saying that because that information is in a document that was passed between the parties in the course of their correspondence, Siam Aero was not entitled to disclose that information to any third party?
Well, if Siam Aero had simply disclosed its bank account details to the fraudster, and completely independently of this agreement, then that's something, as your lordship says, they have a perfect right to do. But they didn't do that. They supplied a sale and purchase agreement saying, if you want to this is the bank account to which the money must be paid in order to purchase the engines.
But providing their own bank account details wasn't in any way causative of the fraud, was it? Because in fact those were scrubbed out. It's not that information which was in any way causative.
I see your lordship's point there. If they had supplied a sale and purchase agreement in blank, without their bank account details in it at all, then the fraudster could have just filled his own in. But I don't see what difference that makes, and it's not a likely scenario.
I'm trying to work out. I think for my part, when I was looking at causation,
yes,
and this comes from the authorities, you've got to look at what is the. Sometimes it's referred to as the obligation or the rule. I think it's referred to in some of the authorities. You've got to. Surely the first thing you've got to do is understand what the obligation is, and what its purpose is. And talking about causation in the abstract without having determined what the clause means and what its purpose is rather an unsatisfactory exercise, it seems to me.
my lord, I will be coming to the question of what the clause means. Perhaps it would be helpful if I made my submissions on that right now.
Well, could you? No, I mean we're just trying to help by bringing up thoughts that have fallen.
It's extremely helpful.
But this page, I'd very much encourage you to follow what you think is the most suitable way of presenting the case. So don't. I mean, you're either going to deal with it now, or else it's flagged for dealing with later. We're
Yes.
equally happy.
I will certainly be dealing with it later.
All right. Okay, we'll let you get on.
I was going to go on to Ms. Coulter's ground 3, which is that the judge's interpretation of the confidentiality clause is wrong. Well, that's effectively the point that we've been discussing, and I'll deal with that in the course of my submissions. And ground 4 is that there's no pleaded case that the emails contained commercially sensitive information. Well, it's pleaded that they contained confidential information, and in my submission, that is good enough. If the words commercially sensitive are required, then that can be added by amendment. The test for striking out is set out, I believe, correctly in the judgment at paragraph 57, and it's summarised as being that the claim is bound to fail. As I've said, Ms. Coulter makes a number of complaints about my client's pleadings. However, if there is a defect in the pleadings, that is not a ground for striking out unless the issue can't be resolved by amendment. And she doesn't cite any complaints about the pleading that can't be resolved by amendment. In my submission, properly analysed, this appeal raises 3 issues, and I will deal with them all in argument. The first is Logix's case that the confidentiality clause covers all communications under the LOI, rather than just commercially sensitive ones bound to fail. Secondly, is Logix's case that the emails relied on by Logix were breaches of the confidentiality clause bound to fail. And thirdly, is Logix's case that the emails caused Logix's payment to the fraudster bound to fail. That's the causation point.
I'm sorry, it's tiresome of me, but would you mind just going back to the first one and
Yes.
say, just go through them again a little more slowly?
I'm sorry. Is Logix's case that the confidentiality clause covers all communications under the LOI, rather than just commercially sensitive ones bound to fail?
Yes.
Secondly, is Logix's case that the emails relied on by the claimant were breaches of the confidentiality clause bound to fail? And thirdly, is Logix's case that the emails caused Logix's payment to the fraudster bound to fail? Now, in front of the judge, we succeeded on issues 1 and 2 and lost on issue 3. The judge held correctly that Siam Aero was arguably in breach of the confidentiality clause. Remoteness isn't an issue as opposed to causation. She struck out the claim on the basis that Siam Aero's breach didn't cause Logix's loss. And we say that she was wrong to do that because, firstly, Siam Aero's breach was the effective cause of Logix's loss, and there was no finding of any break in the chain of causation. And secondly, in any event, the issue of causation and remoteness, if it had been an issue, and it wasn't, was far too complex and fact-dependent to be resolved on a summary application. The factual background to this case is set out in the skeletons, and there is no substantial dispute as to the facts of what happened. in summary, a fraudster managed to insert himself into the email communications between Logix and Siam, so that after the 29th of July 2024, all email communications between the parties were through the fraudster. So far as this appeal is concerned, the communications on which I'd asked the court to concentrate are emails dated the 13th of August 2024, by which the Siam sent the fraudster signed sale and purchase agreements and invoices, both of which had Siam's bank details included. And that enabled the fraudster to send them on with the bank details for payment, altered to his own account at a different bank. So far as the invoices are concerned, the court should be aware, if it isn't already, that the form of the invoices was very important, because Logix had instructed Siam by telephone how they wanted the invoices to be drawn up, and the invoices were drawn up in exactly that form, which of course lulled my clients into a completely false sense of security. Now, my lords, I was going to show your lordships and my lady the various key documents in the case, but you may already have seen them.
Well, as you like. I mean,
Well,
I think our understanding is that the first time that the fraudster breaks cover is with the chasing
yes,
email,
yes,
which, as it were, had the colour of genuineness, because it was a chaser to a real
yes,
email,
yes,
and so it's evident that the fraudster must have, before that time, and probably before the time that the original genuine email was sent in the early hours of that morning, have got into the system.
yes.
So I think we've understood that, and then afterwards, both clients conducted themselves oblivious
Yes. Well,
to what had taken place.
yes, well, obviously, your lordship has understood how the case worked perfectly. I will just describe in a little more detail what happened with the signed sale and purchase agreements and the invoices. But I won't refer to the documents in the bundle unless.
Well, if at any point in your explanation we feel we haven't followed
yes,
some important detail, we'll just ask.
It's not complicated factually at all. The Siam Aero sent signed sale and purchase agreements to the fraudster with its correct bank details. The sale and purchase agreements were quite long. They contained a lot of standard terms, and then, as is common in this kind of contract, there was a two-page annex which contained all the commercial terms and the details in boxes, and there was a box for the seller's bank details, and when the SBAs were sent to the fraudster, that box obviously contained the correct bank details of Siam Aero. The fraudster then scrubbed out Siam Aero's bank details and inserted his own and sent it on to Logix.
I don't know why we're assuming it was a man.
Oh, sorry. There's no reason to assume it's a man, no, he or she. And then exactly the same thing happened with the invoices. The invoices were sent in the correct form as asked for by Logix. by Siam Aero to the fraudster with its Siam Aero's correct bank details inserted. They were then manipulated by the fraudster. The fraudster's bank details inserted and sent on to Logix. And as a result, Logix paid the purchase price to the fraudster's bank. And I think that's all common ground, and all according to the finding of the judge. And our case is that, and I think it's obvious that had those documents not been sent to the fraudster by Siam Aero, then the loss would not have been suffered. In paragraph 25 of my skeleton, I set out some of the judge's key findings and summarise my answer to them, but I don't think it's necessary to read that section. And I will come straight on to what I've called issue 1. That's the interpretation of the confidentiality clause. Now, the judge held, well, I should say, at first instance, I made exactly the same submission that I'm making to your lordships, i.e. that the confidentiality clause covered all communications pursuant to the LOI, not just confidential or commercially sensitive communications. And she rejected Siam's primary case, which was that it covered only commercially sensitive information relating to the other party, so that if Siam Aero sent the fraudster information that Siam Aero had, that wouldn't be a breach, and the judge rejected that.
So when you say all communications under the LOI,
Yes.
how wide does that
I think it's
cover? Does it mean every incident of the communications between these two organisations?
sorry. I think what it says is documents and information. Could I refer to the LOI itself?
Yes, I mean it's just. I mean, we understand that there's, as it were, you could read the clause in a broad way, or you could read it in a narrow way, and that was part of the discussion, as you say, below.
Yes.
But would you like to help us with what you say the exact parameters of the broad reading for which you contend should be?
I say that point C in the clause covers any information and documentation provided under the LOI. That's what the LOI said, what clause 14 of the LOI says. Could I just refer your lordships to that?
Yes, 101.
It's once.
We have
I have it as 170, and maybe it's in more than one place.
Well, we have a helpful tab, which is tab 9, which is relevant contractual
I have
clauses.
tab 12. I hope your lordships have the same.
Well, just so that we can make sure that I have 101.
I'm looking at supplemental bundle 170.
I see. All right. So I'm in the
It's the same
full bundle. Right. Well, it doesn't matter if they're the same.
Well, I don't think it matters.
No.
I'm at 170 of the supplementary bundle. What the clause says is that buyer and seller acknowledge and agree, A, that this LOI contains commercially sensitive information. Contains, so it's only referring to the information contained in the LOI. B, to maintain any information and documentation provided hereunder on a strictly confidential basis. So any I suppose there might be communications that don't satisfy the provision that they're information or documentation. I imagine if there was an email saying let's have a telephone conversation today at 12, that might be not information or documentation.
No,
But
but what happens if instead of saying let's have a conversation at 12, there is a conversation between the two principals in which obviously sensitive commercial information is exchanged between them.
Yeah.
So where that comes under information.
That would be information, yeah. And documentation if there was a record of the meeting. And then C, that it will not disclose such information and documentation to any third party. And in my submission, it is obvious that such information and documentation is a reference back to information and documentation provided hereunder in B. Miss Coulter's case is that the disclosure obligation is limited to the information referred to in A. So that would leave the parties being, so far as this agreement is concerned, prohibited from disclosing documentation contained in the LOI, but free to disclose any other documentation or information supplied pursuant to it. And in my submission, that is a hopeless proposition. First, because the reference to information and documentation is plainly a reference to the words of B. Second, the effect of her interpretation would be that the parties had agreed that the information and documentation under the LOI should be maintained as confidential, but that the restriction on disclosure should not apply to it, which is completely illogical. And thirdly, it can't have been the intention of the parties to confine the restriction to the contents of the LOI, because that would not make sense commercially or in any other way.
Can I say that, as I understand it, there are 2 points of dispute between you. One is the question of whether it only relates to commercially sensitive information.
Yes.
And the second point, as I understand it, is whether or not it relates to your own information, whether you're agreeing that you will not only keep information provided to you confidential, but you will also keep information you have provided confidential.
I don't think Miss Coulter is running that second point in this appeal. My understanding is that the point she is running is that C refers to A, but not to B. So
Why does C, on one reading, not refer to A via B? Isn't it? I mean, I'm just throwing this out.
yes,
To see where it falls down. But isn't there a strong inference that information and documentation under B refers to commercially sensitive information and documentation? So otherwise, we get into the sort of nonsenses that we've already been discussing about banal information in the hands of anybody who cares to Google is somehow contractualized simply because there's a commercial discussion going on. I mean, it isn't one solution to this to say that any information or documentation could have been expanded to say any such commercially sensitive information and documentation.
well, it could have said that, my lord, but it doesn't.
Well,
No, sorry, but as a process of interpretation, what's wrong with that?
Well, what's wrong with it, with respect, is that C says that the parties will not disclose such information or documentation. And that's a reference to any information and documentation
Well, I
provided hereunder.
understand you say
There's
that.
no
but
limitation on it.
I'm just drawing attention to the fact that it might be thought to a first-time or even second-time reader that the intention was that these clauses would work together.
Yes.
I mean, they're not well drafted, but they were intended to work together as a coherent explanation that anything that you learn that's commercially sensitive as part of this, or anything that I learn, we're going to keep between ourselves. And sort of splitting it up by individual parts is not the only way of doing it.
Right. There's also a reference to documentation as well as information.
Yeah.
And in my submission,
Well,
a party
A can't say documentation because the LOI can't contain commercially sensitive documentation. It is the document.
I think it may have attached documents and referred to the particular engines. Given what the parties' intentions must have been, it is in my submission inconceivable that they would have been happy for the draft and signed sale and purchase agreements to be sent to a third party. They must be included.
So what
But
does
those would be commercially sensitive. Sorry, but they would be commercially sensitive, wouldn't they?
They would. Yes.
They would. Yes, that's right. So,
Right.
so perhaps whether it's or not it's commercially sensitive doesn't matter. Though I still maintain that the broad interpretation, which was accepted as arguable by the judge, was that any information and documentation provided hereunder is not to be disclosed.
Well, was there any argument about what disclose means? I mean, if somebody burgles my house and steals something, as it were, I haven't let them have it. What is disclosed to be understood as meaning in the context of a clause of this sort?
I can see that in that case, there might well be argument about whether that.
In this case, it wasn't, by the time the matter reached the judge, suggested that any party had knowingly parted company with this information to a third party, and doesn't encompass at least some degree of failure of responsibility, whether it's to do with carelessness or bad systems or something of that sort. I mean, disclose seems to import, it might be said, some element of agency in what you're doing.
There was a short argument on that before the judge, but she accepted that it was at least arguable that disclosure could be inadvertent.
It seems strange that how is that not the sort of point that is readily capable of being dealt with on an interlocutory application of this sort? It's not going to get any better at a full trial. Was the court not called upon to reach a view about that, or is it okay to put it over for another day?
I'm not going to try and persuade your lordship that this is a point of such complication that it can't be dealt with by your lordships. But I do. This is a strikeout application, and it was regarded as arguable by the judge. Presumably regarded as arguable.
Is there something in the judgment about disclose? I'm sure there may be. But
yes, there is.
Right, can we just alight
I'll
on
have
what
to find it.
she dealt with that?
sorry, I thought I might have the reference.
We'll find it, sorry.
Sorry, no, I can't.
75, coming upon a submission.
Is the reference to an operations.
75, 82, 96 is the sort of territory.
Sorry, page
75, or in paragraphs of the judgment.
Yeah,
75, 82 and 96.
I'm sorry, I couldn't find that. I think that I know that she does deal expressly with disclosure, and it may be that maybe she's when she's looking at my submissions.
Yes, it's 101. End of.
Right, thank you, my lord.
I don't know what stage court is going to take a view about something like this, but the judge decided not to,
Yeah, that's it.
in the context where she wasn't going to, where she was against you on the call point. But anyhow, it does seem to me reading this that disclosure is a word that isn't, as the judge says it, obvious.
Your lordship mustn't forget, and I'm sure hasn't, that what happened here was that the documentation wasn't left by an open window or left on the chair. It was sent directly by email to the fraudster.
Yes, but
If that isn't a disclosure, I don't know what is.
The communications on which you're relying, not the original communications to the fraudster, are they? As part of 2 weeks on.
They're not the first, yes. Yeah, they're not. And I entirely accept that both parties were deceived by the fraudster into dealing with him. But that doesn't make sending prohibited information to the fraudster any less a disclosure, unless one is prepared to somehow read into clause 14 of the LOI a disclosure isn't a disclosure if it's inadvertent. And in my submission, if the parties had wanted to restrict it to inadvertent disclosure, they would have said so.
It did occur to me that the way the judge approached this might to some extent be affected by your pleading at paragraph 3 of your draft amended particulars of claim, where you said it was within the contemplation of the parties that the disclosure of confidential details of the sale process to a third party might allow a fraudster to divert payment to himself. Did that form any part of the argument?
No, it didn't. That's remoteness, and I think Lord Justice Males, when he gave permission, said that remoteness wasn't an issue in the appeal, and it's not being treated as one by Miss Coulter and me.
Yes, I just wondered whether you used it as a basis for invoking any sort of factual matrix which affected the construction of clause 14.
I didn't put it that way. No, that was in order to deal with a submission that I thought might be made, that it wasn't in the contemplation of the parties that this sort of loss could be suffered as a result of the breach.
For my part, I don't have any difficulty that if there's a contractual duty of confidence,
Yes.
inadvertent disclosure to a third party is a breach of that clause, or potentially a breach of that clause. I think
if one looks at the wording of the clause itself, then inadvertent disclosure is covered.
What I'm more interested in.
You'd have to be reading it. Sorry, my lord.
No, no. Well, what I'm more interested in is what you say is that what you say is the meaning and purpose of A, because it seems to me on your interpretation it serves no purpose, because you're saying that that this covers all information and documentation, whether or not it is commercially sensitive. So, what is the purpose of A?
So that any commercial negotiations between the parties are confidential and can't be disclosed to any third party.
But that's dealt with by B and C on your case.
Yes, and A deals with the LOI itself.
But why is it needed?
Because the LOI isn't a document produced under the LOI. I mean, it could have been. I agree, it could have been differently drafted.
But surely information and documentation within the LOI is provided hereunder, isn't it?
Well, in my submission, not. It's either something is either in the LOI or it's provided under the LOI, which means the same as pursuant to the LOI in my submission. So I mean, it could have been drafted so that you didn't need A at all. You could have said all information and documentation relating to this project, which would have included both, but that's not what they did.
But what this clause is about, in common with similar clauses in many commercial contracts, is about maintaining the confidentiality in commercial information between two parties engaged in a relationship.
Yes.
What it's all about is preventing it being disclosed to competitors.
Yes. Maybe. But
Well, is it yes or is it maybe?
Sorry.
Is it yes or is it maybe?
I would say not only that, it's preventing it being disclosed to fraudsters as well. I'm sorry to be repeating myself, but the question of whether the parties contemplated a breach of this clause leading to this kind of damage is not part of this appeal.
Well, causation is part of this.
Causation is part of it. Remoteness. I know that some people use remoteness to include causation, but I'm not doing that.
But causation, I think there's some quite clear dicta that in considering causation, the starting point must be the purpose and scope of the obligation, sometimes referred to as the rule.
I'm sure your lordship is right.
We haven't got chitty, but that's.
I'm a little surprised to hear that, because I would have thought the nature and scope of the obligation is the thing you look at first, and that's what we're discussing now. Whether it was breached, you look at second, and then the third thing is whether the breach causes the loss.
Yes, but causation, well, we haven't got it, but it's referred to in passages from McGregor that you put before us. It's glue based on monarch, and the question is whether it's an effective dominant cause.
Well, the authorities, two of the authorities that I've brought say that it must be a cause, but it doesn't have to be a dominant cause.
But in any event, the other authorities we haven't got, but they're all referred to in chitty, say that in considering that, you have to look at the scope and purpose of the obligation.
In considering whether it's a cause, you have to look at the scope and purpose of.
Because what Galoo says is it's a matter of common sense.
Yes, but that I think has been criticised. It's certainly criticised in McGregor, and in other cases. which say that it's not satisfactory to leave it to common sense. I could, if I have the opportunity to do so, I could research that and provide your lordship with details of the criticisms of Galoo. I suspect they may be in the passage in McGregor that is in the authorities bundle, but I don't know.
Well, it's Chitty 30075 and dictum of Lord Hoffman in Environment Agency and Empress, and further references to the first instance and the Court of Appeal case decisions in IG Index 2015 EWHC 3390 and 2018 EWCA.
Sorry, could your lordship repeat the reference?
Well, why don't you have a look at Chitty 30075? Yeah. It's got all the references there.
And the cases are cited in that paragraph.
Yes.
Yes. Thank you very much, my lord. I will do that. And if the court is going to reserve judgment, then I will make sure that I provide a written response to that and maybe I can do it over lunch.
So,
but I have my doubts. It's an important point. But anyway, my submission would be that considering the extent of the obligation and causation are two separate points. That is my submission.
But how can you say that in the light of the Macmillan case, where the analysis there is in relation to the scope of the obligation being to protect against fraud?
Yes.
That's looking at the purpose of the obligation, isn't it?
Yes.
Saying it's the direct result of the breach is the fraud.
Yes, and I would say that the scope of the obligation goes to remoteness, and the issue in Macmillan, or at least one of the issues, was whether the fraud of the clerk broke the chain of causation between the negligent issue of the cheque and the bank's loss.
There's a structural distinction, isn't there, between that case and this one? In that case, you had the complaint about behaviour by the principal in being careless with the cheque.
Yes.
And then you had the fraud, and then you had the loss.
Yes.
Whereas would it not be logical to see the order of the first two as being reversed in this case?
No,
you have the fraud,
yeah,
followed by behaviour which is being argued about at the moment, as to whether or not it is objectionable or negligent or whatever, or indeed just causative. But between the two, there's a different structural.
Yeah. Yes. There are
stages.
On causation, there are two ways that fraud might come into this, and I'm going to deal with them both when I come to causation. One is whether the forgery broke the chain of causation between the provision of the sale and purpose contract to the fraudster and my client's loss, which is the situation in Macmillan. And the other is whether the, as I think is Miss Coulter's case, whether this is all the result of a fraud starting on the 29th of July.
All the fraud.
And which is, I think, the point that your lordship was putting to me. And my answer to that is that may be regarded as a concurrent cause, but it doesn't matter. The only thing that matters on the authorities is whether this disclosure caused this loss. Obviously, if the fraudster had been before the court, his fraud would have been would have been regarded as a cause as well, and he would have been liable. But we're not in that situation. The mere fact that there is another cause of the loss does not assist a defendant if he caused it himself. And I will be referring your lordships to authority on that, obviously. I think I've said everything that I was going to, and probably everything I can, on the subject of interpretation of the clause. I just note that in her skeleton, Miss Coulter doesn't set out any actual argument on this subject, so I might have to come back to it in reply. Secondly, was the clause breached by the provision of these documents? If I'm right about interpretation of the clause, and even if the clause is limited to sensitive information, then each disclosure by Siam Aero to the fraudster in particular of the draft and executed SPAs and the invoices was at least arguably a breach of the clause. If such, the judge did find that it's a conclusion one can get from reading the judge's findings together, and in particular, the judge decided that it was arguable that disclosure could be inadvertent. In my submission, the judge was right about that. If the parties, one must look when dealing with contractual interpretation. I must start with the words of the contract, and if the words of the contract are clear as they are here, then in my submission it's not permissible to add in words that aren't there, like inadvertent, simply because the court thinks that that's would have served the parties' purposes better than the clause is drafted.
The most obviously commercially sensitive piece of information that was passing back and forth here was the price, isn't it? The price that was being paid for these engines.
Well, the sale and purchase agreements, I haven't put the whole of them in, but they deal with they cover a lot of boilerplate contractual terms, plus all of the commercial terms of the sale. And in my submission, there is, including the condition of the engines and the list of life-limited parts, which the two engines had. One of which had been they found more parts and put them in. In my submission, it's hard to imagine anything more commercially sensitive than that. And I don't think you can take a commercially sensitive document and pick out of it one particular term, like the bank details, and say, oh, the rest of it's commercially sensitive, but the bank details are not. Either the document is a commercially sensitive document or it's not. And these documents, whether they were commercially sensitive or not, and they were definitely provided under the LOI. And so were definitely to be maintained on a strictly confidential basis, and definitely were not to be disclosed. So in my submission, there is plainly a breach.
Forgive me, the gist of your case is not that any of this information was used by the recipient, the fraudster, in a commercial sense.
Yes.
it wasn't used to compete with or to in any way trade on the basis of the information received.
Yes.
So, in a sense, all of these issues about what particularly was sent and what was or wasn't commercial doesn't matter. Your point is that there was a breach by supplying commercially sensitive information,
Yes.
and but for that having been provided to the fraudster, he would
Yes.
not have been able to intervene effectively to procure payment.
Yes.
So you say, first of all, you say that's the but-for element of causation satisfied.
Yes.
I think, and I don't see any problem with the but-for aspect. Confidential information was supplied to the fraudster
Yes.
of some nature, and that was part of the chain by which the fraudster perpetrated the fraud.
Yes.
And without that, there wouldn't have been a fraud.
Yeah.
But none of that seems to me addresses then what you're going to come on to, I understand, which is whether it's the effective cause.
Well, in my submission,
But for isn't enough, is it?
I think my submission would be that but for is the starting point, and then you look to see whether there's anything to prevent it being a cause.
Well, that's not the test, though. The
I
test isn't
struggled-
but for.
Sorry, I struggled in reading McGregor to find any definition of what effective cause, and I believe that the latest edition of McGregor emphasises that but for is the starting point. So having dealt, I mean, I haven't said very much about breach of the clause. In my submission, it's not subject to the inadvertent question. It's obviously a breach, and I don't believe the clause should be interpreted as restricting the disclosures to advertent disclosures. I make the same point about Miss Coulter's skeleton on this. She doesn't set out much argument on why there wasn't a breach, possibly because she accepts, and I'm not asking her to answer this now, she accepts that that if I'm right about interpretation of the clause, then there plainly was a breach. But again, I may have to return to this in reply if any new point is taken by her. Now I come on to causation. And in my submission, Logix has an arguable claim against Siam unless the court can be satisfied that its loss was not caused by Siam Aero's disclosures to the fraudster, and I don't see how it could be so satisfied. As I said, the mechanism the law caused loss was as follows. In breach of the confidentiality clause, Siam sent the signed SPAs and invoices to the fraudster. Those are the only documents which contained instructions for payment to Siam Aero, and the only documents which could have allowed the fraudster to change the instructions. No other document exchanges could have caused or contributed to the loss, nor could any document sent by Logix to the fraudster. The fraudster then manipulates the bank account details on the SPAs and invoices provided by Siam Aero to him or her, so that the fraudster's bank account details appear instead. This leads directly to Logix paying the price of the engines into the fraudster's bank account. There are three steps naturally and directly following from one another. One, Siam Aero sends a document to the fraudster directing Logix to pay into an account. Two, the fraudster changes the bank details, and three, Logix pays the fraudster, and each leads naturally one from the other. And in my submission, nothing that happened before those documents was supplied to the fraudster could be causative. And so the fact that a criminal act by the fraudster intervenes is not or not necessarily a defence. And that's the London Joint Stock Bank case. I was going to address your lordships on that case, but I can see that you've already looked at it, so it's unnecessary for me to do that.
Well, don't avoid any submissions that you think are important arising from it. I mean, we're obviously aware of it, but if you want to, in a sense, the judge distinguished it, and you rely on it. So we need to deal with that point.
I will deal with the judge's distinction. Yes.
Yeah.
But so far as that case is concerned, I think your lordships have understood it, and the parts of it which I rely on are sidelined and are actually quoted in my skeleton. So I think we don't probably, to save time, I won't turn to the case itself. Now, at para 106 of the judgment, the judge identifies 3 points of distinction between that case and this case. But in my submission, none of them stands up to analysis.
This is skeleton 36, is it? Yours, but just so we don't
yes.
need to write everything.
Well, I'll deal with that quickly. Firstly, for reasons I've given, remoteness is not an issue in this appeal. Lord Justice Mail said that it was a red herring, and nobody's taking any points about it. If there were a question about whether or not the parties did or should have contemplated this kind of loss arising from a breach of the confidentiality clause, then in my submission that's something that couldn't possibly be dealt with summarily, because one would need to much more background detail about what the parties knew. I mean, one thing which isn't, I think, in evidence before the court is that Siam Aero had actually had the victim of a similar scam before, and that sort of thing would have to be resolved at a trial with evidence. Second, and I think this is perhaps the most important point, in the London Joint Stock Bank case, the judge said the firm was at fault, and said that there is no equivalent in the present situation. In my submission, that's an impossible finding, as disclosure of the documents to the fraudster by Siam was a breach of the confidentiality clause. If it wasn't, obviously, I lose anyway. If it wasn't a breach, but if it was, and the judge found that it arguably was, then that is a fault sufficient to found a claim for damages. And I simply, with the greatest respect to the judge, failed to understand why she says that the Macmillan, the principles set out in the Macmillan case can only apply to conscious negligence and not to a breach of contract. And that is Ms. Coulter's argument as well. However, the section in McGregor on intervening acts of third parties in tort, which is paragraph 9208 in the authorities bundle, states that there are authorities on intervening acts of third parties in tort cases, but very few in contract cases. So the authorities deal mostly with tort. However, the authors of McGregor say that say that they can see no reason why the authorities shouldn't apply equally to contract cases. Would your lordships
Yes,
like to
thank
look at that?
9208 on page 3.
It's the first. I think it's the first page of my extract. And there's no explanation from the judge or Miss Coulter why breach of contract won't do in these circumstances. And I can't see any principal reason why there should be a difference between causation in tort and contract. So the issue is whether loss was caused by Siam Aero, and on the authority of London Joint Stock Bank, intervention of a fraudster into the transaction does not break the chain of causation.
Forgive me, sorry.
I beg your pardon. Can I just, on a very banal point, we're looking at a section which is entitled Consequences Following Upon a New Intervening Force.
Yes.
All these are sort of terms of art in this discussion, but what's the new intervening force in this? What's new about it? How does that work?
It's the forgery.
Yes, I understand that because we've discussed.
I may be addressing a point that isn't being made against me, but I thought it might be suggested, and this is why I brought that case before the judge.
No, but just in this case, I'm just looking at new intervening force and trying to work out for myself. Is there a new intervening force in this case? I mean, there's clearly an intervening force, but what is meant by new intervening force?
It's an act by a third party which intervenes between the breach of contract and the loss.
Right, so new doesn't mean anything.
Well, the forgery is a new act.
Not between the breach of contract and the loss.
Yes, but we know there was a loss. I've argued that there was a breach of contract, and the reason I brought London Joint Stock Bank was first of all because I thought it was an analogous factual situation to this. And secondly, because of the issue of the new intervening force, I thought it might be said against me that Siam Air's sending the material to the fraudster didn't cause the loss because there was an intervening act by the fraudster of forgery, forging the bank details. It may not, maybe that's not being said against me, but if it is, that doesn't work because of the principle in the Macmillan case. And does that answer your ladyship's? I'm very concerned to make sure that I do my best to answer the court's questions. It's terribly useful for advocates to have these questions.
Can I ask you this? I think we've slightly glossed over what's actually said in paragraph 9209. The sentence starting to this, there is one important exception. Authority is more profuse in contract than tort itself. This is the situation where an intervening voluntary act of a third party intended by them to cause damage.
Yes.
That's this situation.
Yes.
Is perpetrated in circumstances where the defendant's contractual duty to the claimant is to take care that such an act does not happen.
Yes.
It is only because the defendant's duty is to guard against the very harm which results that the law holds him liable.
Yes.
So the starting point is that where you have an intervening act by a third party which is intended to cause the damage, sometimes referred to as a novus actus, you wouldn't prima facie be liable. But what makes you liable is that the duty is to guard against that very harm. In other words, in Macmillan, the duty is precisely to fill in the check carefully enough that a fraudster cannot just increase the amount or change the name or whatever.
Yes.
And that is the very thing that the duty is to guard against. And that's what this is saying, isn't it?
Yes, it's one of the things, and obviously another thing is a mistake by the bank in reading the check.
But that's, forgive me, but that just to make it clear, this is where I was saying to you that I think this is where you have to look at what the purpose of the obligation is.
Yes.
Because here it's being said that what changes a novus actus into not an intervening act that breaks the chain is what is the purpose of the duty?
Yes, but as I think I've said before to your lordship, that is going back to remoteness, which isn't a part of this appeal.
Well, no, forgive me, but this is, and you're showing it to us as part of the test as to whether or not an intervening act breaks the chain of causation.
Yes, the remoteness question is what was in the parties' contemplation. What kind of loss was in the parties' contemplation when they agreed that contractual term, which is exactly the point that your lordship is asking me about. But I'm sorry if I sound like a broken record. Remoteness is not part of this appeal because Lord Justice Males said it wasn't. And as a result, Miss Coulter and I are not treating it as one.
Forgive me, the novus actus isn't a remoteness issue; it's a causation issue.
Yeah. Well, sometimes people call. I think McGregor, the chapter on causation is actually. If you look at the heading of the page, the chapter is called Remoteness of Damage. So McGregor doesn't make the distinction, but there is a distinction. One is what is the intention of the clause, and the other is did the breach cause the loss. Even if your lordships don't accept what I've said, that remoteness isn't part of this appeal, though I hope your lordships do, because it's right. In my submission, it's not a point that can be dealt with on a summary application. It would definitely require evidence from the parties as to what they thought the loss. The loss that might be suffered as a result of breach of this clause might be, and also possibly expert evidence on the incidence of this kind of fraud. But I think we all know it's very prevalent at the moment. But for those two reasons, I ask your lordships. Well, I submit that it would be quite wrong for your lordships to dismiss this appeal on that remoteness basis.
Well, Chitty does have separate sections on causation and on remoteness. Right. And under the section on causation, it has, first of all, requirements of a causal
connection,
Yes.
paragraph I mentioned to you.
Yeah.
And then it goes on, intervening acts of third party, duty to prevent third parties act, etc.
Yeah.
So that is looking at third party intervention as a question of causation.
It's a
There is a separate section on remoteness.
I think, well, it's a separate section on intervening acts, and obviously the question of remoteness comes in on when one's looking at an intervening act, because one has to ask whether part of the whether it's in the party's contemplation that some fraudster might do this if he got hold of the confidential information. But that's a remoteness issue, not a causation issue. It's a question of what the obligation was, not a question of what caused the loss. I'm going to come on to a different point, which is whether it matters that the transaction itself was part of a much wider deception by the fraudster, which is Miss Coulter's case. And in my submission, this might make the wider deception a concurrent cause, but it doesn't lessen Siam Air's liability for its breach of contract. I refer to the case of Heskell against Continental Express, which is the first case in the supplementary bundle of authorities that I think Hope was supplied on Monday.
Not to me, it wasn't in hard copy. I've only got one bundle of authorities.
Reference to Heskell, was it?
Has anybody got
Yeah,
one?
If it's not,
Is
if it's on
every-
your electronic,
Are you all in the same position?
I think I have an electronic version.
yes.
Yes.
Just let me see. Just let me see if I got it electronically.
Thank you very much. I don't know why. I certainly asked for it to be supplied in hard copy, and I was told it had been. I apologise very much for that.
No, please don't worry. It's
My lord, we do have one spare hard copy if that's of any assistance.
well, that's
very helpful.
That's very helpful. Thank you very much. Are you going to refer to more than one? Are you,
There are two.
Right, and they're both in that file by the look of it.
It should be.
I haven't even got it electronically.
Thank you, Ms. Coulter.
The first case is Heskell and Continental Express. Mr. Justice Devlin, as he then was, in 1950. I think it's quite a well-known case. What happened in that case was that a warehouseman had been instructed to deliver a cargo to a ship, and he failed to do that. And due to the negligence of the forwarding agents, a bill of lading for that cargo on that ship had been issued, even though the cargo wasn't there. And the shipper succeeded in claiming his entire loss against the warehouseman for breach of contract, despite the bill of lading being a cause contributing equally to the loss. And page 16. I'm sorry, I'm sorry it's not sidelined. Could I ask your lordships to read from 15F down to 16D, or is it convenient for me to read it out?
We're looking at page numbers here, yes?
It's page 15
Thank you.
in the bundle.
Right, 15.
page 15, letter F, the defence of novus actus interveniens,
to 16D.
down to 16.
Well, it's probably simplest if you just allow us to look over that.
The last bit was sidelined, but not the first bit, but I think it's useful to read through that.
Yes, so we're really focusing in on A to B. This, I think, is what happened here,
Yes.
and after that.
Yeah,
So
that's-
this is rather the opposite. I mean, I'm not saying it's conceptually different, but it's rather the opposite, namely that the whole thing was set off by the warehouse man.
Yeah. But he's setting out what the principle is in relation to tort, which is that the wrongdoer can't excuse himself by pointing to another cause. And then the case before him was a contract case, breach of contract by the warehouseman. And so he goes on to consider what the situation is in contract. Going down on page 16, I'm not asking your lordships to read it through, he says the authorities show there are differences between the authorities on tort and contract in relation to second causes. But at the top of page 17, the sideline passage, he says, I do not think I have to deal here with a breach of contract, which by the operation of some other cause is reduced to a cause of lower efficacy. It may be the term a cause is, whether in term tort or contract, not rightly used as a term of legal significance, unless it denotes a cause of equal efficacy with one or more other causes. Whatever the true rule of causation may be, I'm satisfied that if a breach of contract is one of two causes, both cooperating and both of equal efficacy, as I find in this case, it's sufficient to carry judgment for damages. Apart from the fact that that's a judgment by a very distinguished judge, it's, in my submission, still good law and correct. The second is the Court of Appeal, County Limited and Giro Zentrale Securities. And this is, the facts are a little complex. A bank agreed to underwrite an issue of shares. It gave instructions to brokers to obtain commitments. And the instructions did not say that the bank would only proceed if investors made commitments to subscribe for 100% of the shares. But the brokers nevertheless informed their investors that 100% commitment was required by the bank. The chairman of the company said he, on behalf of unnamed principals, could give indicative commitments, but some of those principals didn't come forward. That led to commitments given to the brokers, being refused on the grounds that the investors who dealt with the brokers had understood that there had to be 100% commitment. And since there wasn't, they were off the hook. And that meant the bank was left with a loss. The bank sued the brokers, who argued that their breach was not the cause, since a number of causes had combined to bring about the loss, particularly the company's failure to obtain commitments from its unnamed principals. The Court of Appeal, the main speech being judgment being given by Lord Justice Beldam, decided that if a breach of contract is an effective cause, the court need not choose which cause was the most effective. And that's page 35 of the bundle. Could I ask you to read the paragraph above the sideline passage? So I think it's helpful, starting between A and B, and then down to the bottom of the sideline passage.
Forgive me, which page?
Sorry?
Which page?
Page 35. Of the bundle. Gilbert Elliott is the broker, and County is the plaintiff bank. Yes, it had been said that the bank itself should have checked whether the company's unnamed principals were good for their commitments.
I'm finding it easier to understand what the judgment means by looking at the head note.
Sorry?
I'm finding it easier to understand by looking at the second paragraph of the head note, which is on page 21.
I'm sorry, I sometimes think it's easier to.
No, you did right. I'm just saying in this instance, there's a clear statement at the second paragraph of the head note. So really the issue in this case might be expressed to be as to whether there was more than one cause of this loss, namely the fraudster getting in plus the documents being sent.
Yes.
Or whether the cause of this, as the judge found, was the fraudster getting in and that the documents being sent was merely incidental to the to what.
I think that's what the judge found. That's why I'm appealing.
No, quite right. But I mean, those are the two,
Yes.
the two possibilities that you're characterising the sending of certain emails by the other party as being causative, whereas the judge found that they were incidental. In effect, I mean,
I'm not sure the judge actually said that they were incidental.
No, I'm interpreting that from the fact that she simply said that
She found that the
fraudster caused the loss.
The fraudster caused the loss, which is a perfectly reasonable finding for her to make in these circumstances.
Yes, but by caused, she meant caused.
Yes, that's right.
And if you have not part caused,
if you have more than one cause, then you don't have to look at which cause is the.
But in your case, for example, the useful case of the warehouseman and the clerk or whoever it is who issued the bill of lading.
Yes.
You had two incompetents. They clearly were both involved in causing the loss.
Well, my lord, assuming that I'm right on the interpretation of the contract, and the judge found that I was at least arguably right. I find it difficult to see why the sending of the contracts and the invoices to the fraudster didn't cause the loss.
Because thereafter there was an independent fraudulent act by an unknown third party,
Yes.
which completely changed things. And these weren't two concurrent causes, is the
No,
argument.
no,
The argument is that this was the act of an independent third party fraudster in a situation where it cannot be said that what Siam had undertaken to do was to prevent that happening.
No, it can be said, my lord, and it is said, and it's pleaded.
Yes, I understand.
It's exactly
what you
pleaded.
say. Yes.
The structure of my submission on this was first to deal with the novus actus interveniens point, and then to deal with what I thought was the judge's point, which is that this is all caused by the general fraud starting on the 29th. And the answer to that in my submission is that that may be a cause, but provided the sending of the contracts and invoices was also a cause, the court doesn't go through the operation of deciding which was the greater cause.
Can we?
Either the contracts and invoices were a cause or they weren't. In my submission, they plainly were.
Can we just think about the facts here again, just for a moment?
Yeah.
I think, as we've established, the starting point of this was the follow-up email on the 29th of July.
Yes.
To your clients.
Yes.
Now, at that point, as far as the evidence is concerned, Siam have no involvement in that.
Yes. It's fair to say that both my clients and Siam have had their email systems checked, and that there appears to have been no hacking. There was, however, a third party involved, the people who were holding the engines in France.
Yes.
And we haven't been able to check their email system.
But for our purposes, for this argument, that email has come from the fraudster, and no fault of Siam can be alleged at that point, no breach.
No.
No. So that's the starting point. The follow-up email goes to your client.
Yeah.
Your client does not spot the changes in email addresses, but it responds to that,
Yes.
which gives the fraudster the document which it can then send to Siam. So in fact, the party who starts this process by disclosing is your client.
Yeah.
And that then leads to a document which appears to be genuine, being your email to Siam, is changed and given to Siam. So Siam is receiving an email which you have provided to the fraudster,
Yes.
for the fraudster, which the fraudster then adapts.
Yes.
So, and Siam thinks that it is receiving an email with genuine email addresses because you have provided a genuine email to the fraudster, which enables him to do that.
I think the truth is that neither Siam knew what my client's genuine email address was because they'd had email correspondence
Yes.
with them before.
Yes.
So I think the position is that neither party noticed the change in email
No,
address.
but the starting point for this, as it were, the starting point was your client not noticing.
Yes, but that's not causative.
Well, we have to look at the overall effective cause of what ultimately happened, don't we?
Yes, in my submission there are two effective causes. One is the fraud in general, if one should call it that, and the other is the provision of the contracts.
It's right to say, isn't it, that the first, on your analysis, the first party to breach the contract
Yes,
was your client.
yes, but it was a breach without any consequences, save that it started the deception of the
Why
two
was
parties.
it any more? I don't understand why it is any less consequential than anybody else's communications. I mean, as soon as anybody gets on board the fraudster's bus, it's the whole thing. I mean,
Yes,
I don't see why your one would be inconsequential, but their one is consequential.
because it directly caused the loss. That's why it's consequential.
But why is there a circularity of action here then? Because your breach of contract has caused Siam to be deceived in a way which renders them liable to you. So why isn't it a circular action? Because on your analysis, you breached the contract.
Because what we didn't cause Siam to do anything.
It did. It caused them to expose themselves to liability for your loss. On your case, you say that they have rendered themselves liable to you, and the reason that happened was because you breached the contract by disclosing information to the fraudster. So you have caused their liability to you.
I accept that both parties were deceived. But I don't accept, with respect, that the mere sending of an email to the fraudster on the 29th caused anything. It needed both parties not to notice the fraudster's change in email address. There were communications going both ways. I entirely agree. But my submission is that the only communications that were causative were the ones on which I rely, because they directly led to the loss.
But if you didn't reply in breach of contract, as you say it is, it wouldn't have happened.
Well, there is another reason why they're not causative, and that is that there was no manipulation. It makes not the slightest difference whether my clients sent these emails via the fraudster or direct to Siam.
Yes, it does, because unless they change your email addresses on it, the fraud stops. They have to change all the emails addresses on every one. Not all of them. They have to change the emails to which Siam will reply, or else the fraud doesn't proceed.
Well, in that case, there might be another. You might say that that's another cause. But
it's not just a cause of your loss; it's also a cause of Siam's liability. If you're right.
Well, my submission would be that it's another cause of our loss, if one looks at it that way. And I think I accept that the fraud is a cause of our loss.
It is, but do you accept it's a cause of Siam's liability to you?
No, my lord, I don't think I can accept that. It's a point that hasn't been, I think, made up till now, but I'm not complaining about that.
Well, I think, I mean,
Sorry?
no offence to my lord, but I think you're entitled to complain about it if. So don't be deterred from doing so. If it's a new way of looking at it, it's appropriate that we recognise that it's new. We have to decide what to do with it, but in a sense, you have an opportunity to respond.
Yes, well, it is a new way of looking at it. It's not a point that's been put to me before. And could I think about it over? I don't think we're going to finish before lunch.
No, we're not
Think
going.
about it over the lunch and adjournment.
Of course.
See if I can give a better answer. My submission is that at the moment is that the only thing you need to do is to see whether the loss was caused by Siam's sending of the contracts and invoices, and if it was, then one doesn't have to look at other causes. But I take my lord's point that it might make a difference if that itself was caused by a breach of contract by us. I might have to look back at the nature of the communication on the 29th, but I suspect that it did contain well, I'll have to look back at it.
You'll have an opportunity to reflect on it.
Yes.
Your case is that any communication is a breach.
I just got a few points on Miss Coulter's skeleton, which is in the core bundle, divider 4, page 53. But they're rather along the, I'll take it quite quickly, they're rather along the lines of what I've already said. I just thought I'd go through the skeleton on this. Paragraph 50, what she says is that there are multiple equivalent disclosures of protected information in breach of the confidentiality clause, not 4 causative disclosures, which have no particular causative potency in themselves. And I agree that there were multiple other disclosures, but they didn't cause the loss. And even if they did, they're irrelevant because it's no defence to say that there is a second cause of loss. Paragraph 51, Ms. Coulter quotes my skeleton and calls it a mischaracterisation of the fraud, but she doesn't say that it's factually wrong. Paragraph 52, it's correct that the fraudster carried out other fraudulent acts and deceived Siam Aero into sending in the bank details. But what that means is that Siam Aero's breach was not deliberate. However, that's not material to the appeal. The confidentiality clause does not require disclosure to be deliberate, and that's para 101 of the judgment that I think we've already looked at. Again, if the emails from Siam Aero cause the loss, it doesn't matter that Miss Coulter can point to other possible causes. Para 53, Logix didn't have a mirror image role. If it provided any documents which were manipulated, they weren't causative. Para 54, it's agreed that remoteness isn't an issue. Para 55A, it may be that Siam was deceived into making its disclosures and thus breaching the confidentiality clause, but breach the clause it did. And I was going to say Though Logic was also deceived, it's not suggested by Miss Coulter anyway, that Logix provided any document causative of the loss. And I will look very hard at the email of the 29th.
Is it the contents of the documents that are causing the loss, or is it the sending of the documents? I mean,
Well, it's the sending of the document.
What is it that? I mean, we've discussed the situation in which both, answering questions to my lord, in which it was proposed that since both communications in both directions were causative of your loss. But I think your case is actually that you weren't at all causative because your communications were of a different kind. Even if
they were. I say first of all that we weren't causative because they weren't communications that required to be or were manipulated. Well, I suppose the email addresses.
Well, not just that.
But my main point is that even if they were causative of the loss, it doesn't matter because pointing to a second cause doesn't assist Siam.
No, I understand that, but I'm at the moment addressing the idea that your ones weren't a cause at all, because I haven't yet fully grasped why their communications were more pernicious than yours in terms of causation. I thought the whole point about the fraud was the fact that both parties were sending things. It wasn't so much what they were sending, it was the fact that they were sending.
It's both. What caused the loss was the fraudsters being able to manipulate the bank details in the contracts and invoices. That's what caused the loss, and he couldn't have done that if the contracts and invoices hadn't been sent to him.
But that's only because he was in the middle. He has to be in the middle.
Yes.
And that means there have to be communications going both ways. Otherwise, he can't do it.
I mean, there were communications going both ways, but they didn't have to be. All that was necessary was that the contracts and invoices were sent to them.
No, because if there weren't communications going both ways, they wouldn't have sent anything. They thought, where have they gone? We're not going to start sending things into a void. So the fraud required communications to be going in a normal way, backwards and forwards both ways, because otherwise one side or the other would have thought, what's going on here? And it would have stopped. So I just gave you the opportunity to deal with this, that I understand your point, that even if you were contractually at fault, you say, subject to anything you're going to add in relation to my lord's circularity argument, that doesn't matter. If they caused it as well, they're responsible because you had the loss. I understand that, but at the moment having difficulty in understanding how you could not be also a cause of the loss because you unwittingly joined in this manipulated discussion, as did they.
Well, I just remind your lordship of the facts of Jura Zentrali, when the plaintiff bank was blamed for causing the loss itself by failing to check its client company's commitments on the share issue, and so even a breach by the plaintiff company itself wasn't regarded.
Well, as I know, I've said I've got that point.
Yes.
But I'm interrogating your further point, which is that actually you weren't responsible at all causatively. You played no part at all. But I think we may have exhausted that.
I think I may have done my best on that.
Yeah.
But my main point is that even if we were causative, it didn't matter.
Thank you.
I think the other points I was going to make, you already have. I formally ask that this appeal should be allowed. And I will come back on my Lord Justice Phillips' point. I hope satisfactorily after the lunch adjournment.
Certainly. Anything else? No. Ms. Page, thank you. That's been interesting and helpful. Thank you very much. Yes. Ms. Cotter.
Thank you, my lord. If I may, in the first place, just hand up the excerpts from Chitty referred to by my Lord Justice Phillips, in case those are of assistance to us.
Yes,
It's just paragraphs 30.075 through to 30.086, which I think was the passage referred to by my lord. We've just had those brought over to court in case they're...
Have we copied Mr. Page before we...
Yes, of course.
Thank you.
May I just suggest those are added to the supplemental authorities bundle insofar as there are hard copies, otherwise perhaps kept as a loose clip for now. If I have a slight dilemma in the sense that I don't think I can improve on the analogy of my Lord Justice Jackson in respect of the fox and the hen house. In my submission, it is precisely opposite to the facts before the court on this appeal, and I gratefully adopt that analogy. And it is important because it is a way in my submission to the core fallacy at the centre of the appellant's appeal, which is this notion that the 4 emails were an effective cause of the loss. That's the starting point on the appeal, and in my submission, the arguments in that respect are entirely without merit. Now, this is of course an email interception fraud, a recognised fact pattern. And in my submission has significant commercial implications if the position for which the appellant contends is correct. Because the consequence of it is that the non-paying party will be liable for the paying party's loss in circumstances where there has been a fraud, the intervention of the fraudster being the fault of neither side, but that what is said, and nothing more than this is said, then that some information was passed in breach of a confidentiality clause.
It's a matter of interest. I mean, as obviously not a specialist in this area, understanding that this sort of fraud is endemic, and seeing how destructive it can be, it comes. You know, the email wasn't invented yesterday. It's a little surprising that there doesn't seem to be any authority at all in relation to this type of issue. It just doesn't help us to decide who's right or who's wrong, of course, on the appeal. But Mr. Page will have his chance later. But since you've mentioned it, is there any thinking about why we haven't been referred to any authorities of any recency about this? Mr. Page, sorry, you.
Well, yeah, there are 1 or 2 or 3 authorities about this kind of fraud.
Right, but they conceptually didn't
No,
relate to our appeal. Is
they're
that
not helpful because none of them concerned a contractual clause like the one we're talking about.
It's the coincidence of the confidentiality clause with the fact pattern.
Yes, I certainly am not aware of any authority.
Well, I wonder, without asking too much extra labour, would you give us a note, maybe between you at some time, if there are the odd case in the reports where litigation has resulted from email interception fraud? It would just be, at least to me, of interest to know where our case sits in relation to other disasters of this kind.
Yes, and if I did that by, say, tomorrow night, would that be soon enough?
It would be more than suitable, but please you can take more time than that and liaise between yourselves to see whether.
I'm sure that Miss Coulter referred to two of them at first instance.
Well, let's take.
Maybe
we won't take too much time about it at the moment, but
yeah.
We will take it from you. Yes, we hear otherwise. They've got absolutely nothing to do with the substance of our appeal, but it is just of interest, at least to me, to know what has so far surfaced in relation to.
Yes, I think from recollection of those cases, the courts have been resistant to the idea that a seller owes a buyer an obligation to secure its email accounts.
Right. It's about that sort of thing. Okay.
Yeah.
Needless to say, my lord, we haven't identified any authorities that are relevant to the issues on this appeal arising in similar or related factual circumstances and email interception fraud. But we will of course cooperate fully in a check of that and provide the court with whatever we can find that might help. In outline, the respondent says that on a proper analysis, the legal issue for the court is whether there's any real prospect of the appellant showing that the alleged breaches, so specifically the 4 emails to the fraudster, are the effective or dominant cause of the loss. Now, there are some bits and pieces in the authorities placed before the court by my learned friend, which refer to the need for the proof of causation, that the breach of contract must be an effective or dominant cause of the loss. But there is quite plainly, I mean, that's in McGregor, although the most relevant passages of McGregor in that respect are not before the court. But they are certainly in the passage from Chitty referred to by my Lord Justice Phillips, simply in the first paragraph of this at 13075. There must be a causal connection between the defendant's breach of contract and the claimant's loss. Causation must be proved first. The claimant may recover damages for a loss only when the breach of contract was the effective or dominant cause of that loss, citing the Galoo case. Now, it is at that stage of the analysis that I submit the appellant's case falls down. And that in that respect, the judge found rightly that the true cause of the loss was the fraudster's intervention, the fraudster's fraud. And she made, in my submission, 2 key findings, which are unimpeachable on the law and on the basis of the propositions of law simply set out in this short paragraph. Firstly, at paragraph 98, that where it's alleged that the breaches of the confidentiality clause were the cause of the claimant losing the purchase monies, that ignores the reality of how the fraud was carried out. And at paragraph 103 of her judgment, that on the wide interpretation of the clause, every single communication is a breach, and that's of course maintained by my learned friend as his case, that there was nothing causatively potent about the 4 emails, that the fraudster needed both sets of communications for the fraud to work, and the judge accepted rightly in my submission that it was unsustainable and artificial to say that the 4 emails caused the loss. The claimant's loss was caused by the fraudster. And at paragraph 107 of the judgment, that it becomes more difficult still for the then claimant if the narrow interpretation of clause 14 was right, because in that scenario, the then claimants must still show that the potential breaches in question were the effective cause of its loss. In other words, that the commercially sensitive information, which at that stage and even now had not been identified, the commercially sensitive information said to be causative, caused the claimant to pay monies to the fraudster.
Could you go back to 103 just for a moment?
Yes, of course.
And at the second last sentence, the unsustainable and wholly artificial sentence, is the judge effectively saying it's artificial to claim that the 4 emails caused the claimant's loss at all? I mean, she's
Yes.
not there leaving room for it being a minor cause or a lesser cause or anything like that. Her interpretation, one might read that paragraph as saying, is that that wasn't the cause, because she follows it up by saying that the loss was caused by the fraudster. So I think, and rightly or wrongly is the issue on the appeal.
Yes.
She saw this as all one way.
Yes.
It was the fraudster and the correspondences that were provoked by the fraud
Yes, that's
were not a cause that could be held against either party.
yes. That is in my submission precisely what the judge found, and rightly so. And that is in part, my lord, the explanation for why Siam Aero hasn't as yet anyway followed the path of what happens if we are wrong in what we say about causation, and there is a finding by this court that in fact the judge was wrong, and there is a possibility at least, or an arguable case, that both Siam and Logix were in breach whenever they sent anything which was intercepted by the fraudster, whether or not it was directly manipulated. And in most instances, those communications are, and we can come on to look at exactly how that works. Because there is now an attempt to differentiate between what my client did in terms of sending documents to the fraudster and what may have been done by Logix, and I don't accept that. Factually, and for the purposes of causation, there is no principal distinction to be drawn on what Siam did and what Logix did. So the logic of that is that if we end up in a scenario where we're wrong about the pure, we could call it the pure causation case, that the fraudster is the cause of the loss and nothing Logix did was the cause of the loss, if we're wrong about that, we are immediately in the sort of universe referred to by my Lord Justice Phillips, where both Siam and Logix are equally at fault in the sense that they have sent communications to the fraudster. Now, one would then look at the consequences of that, and precisely as my Lord says, in respect of circularity of action. Because it would be impossible, if that's right, and that's their case, it becomes logically impossible to sustain. Because at the beginning of the fraud, and I was going to come on to this, and I will do so if I may, in respect of the documents themselves, what one sees is an intervention by the fraudster which is not suggested on this appeal to be anybody's fault, which gives rise to a communication from Logix to the fraudster, which then prompts the fraudster to send material to Siam. The chain then continues. Now, the way in which our primary position is that the cause of the loss, as the judge found, is the fraudster. That's the beginning, and that's the origin, and the fraud is underway from that point, and that therefore there's no causative potency to the 4 emails. But if that's wrong, then I would respectfully adopt the analysis suggested or explored, rather, with my learned friend, which is that the case is hopeless in any event, because it leads to the logical result that that Logix is responsible for Siam's liability, if it has any. And it's inescapable.
If it's a circularity, though, then there isn't a claim.
Yes. Yes, there's no claim to begin with. If that's right, And of course, we say that it's not. But if this court were to find that there is an arguable case that both sides were equally at fault, equally in breach, and crucially causatively so in providing material to the fraudster, then that equally, in my submission, spells the end of the claim. But we have addressed it on the basis that the judge was right to find that the fraudster caused the loss.
Well, when granting permission, Lord Justice Mail said it was quite hard to fit this into the confidentiality clause. I'm just considering this, that let's suppose there wasn't a confidentiality clause, but a fraudster got into the communications backwards and forwards, and one of the parties suffered a loss as a result. In the absence of a confidentiality clause, is the consequence that the person who didn't suffer the loss is always going to have to pay the costs of the person who did?
Well, it would depend.
Or does it all depend on the confidentiality clause?
It may depend then on
negligence, or
the factual circumstances, the relationship between the parties, and whether they may be such as to give rise to a tortious duty. Now, a tortious duty was pleaded in this case originally, as you may have or may not have seen,
yes.
But that claim has been deleted as of March, before the hearing before the judge. As you'll also have seen, paragraph 4 has been maintained in the amended particulars of claim for reasons that are not entirely clear to me, and it hasn't been touched on this morning. But that paragraph posits a rather different interpretation of the confidentiality clause, which certainly I understand to be closely allied. There's no allegation it was breached in that sense, and that's important. There's a faint attempt, at least I understood it to be, to keep that interpretation of clause 14 alive, but there's no allegation that it was breached. It's about a duty to take reasonable steps. In fact, it may actually help to look at it, if we may. It's in the amended version of the particulars, which is in the supplemental bundle. Tab 4,
47.
page 47. To take reasonable steps, including security for its email and computer systems to protect the information and documentation from falling into the hands of third parties. Now, that seems very closely linked to the deleted paragraph 19, and then the deletion of the plea of negligence and or breach of duty in paragraph 20. Which was a tort claim to take reasonable precautions for the security of its computer and email systems. Now, this claim isn't pursued before you, and certainly there's no allegation of a breach of a contractual duty to take reasonable precautions, because that, if such breach were alleged, it would have to be done properly and pleaded fully, and there would have to be a full plea as to why it said that my client had breached such a duty, and then we would actually, of course, run into the same question in respect of whether it was an equivalent breach was being committed by Logix at the same time.
I think you're helpfully answering the point I asked you, but that you say, as it were, has now fallen away.
That's fallen away
paragraph
here.
4. Yes, but if we then go back to the world in which there is a confidentiality clause, as I understand your submission, if you're wrong, and the appellants are right, you say it's in a case where there's a confidentiality clause of this perfectly normal nature, it's hopeless to require a party who participates equally in victimhood of a fraud to indemnify the person who happens to end up losing as a result of the fraud.
Precisely so. It is completely without principle. And certainly on the issue of causation before the court today, it is, and I put this deliberately highly, it is completely without principle. And of course, and we say that the wholly sort of inapt structure that is then sought to be imposed on the facts here is that you then have 4 emails that are sent at different times, but a chain of causation, it's said, between what Siam did in sending those 4 emails and the loss, that is the Logix sending money to the fraudster's account. And that nothing that Logix did broke the chain of causation, it's said, and isn't alleged to have done, and that nothing the fraudster did broke the chain of causation, and that it's therefore irrelevant if the fraudster intervened. We don't accept that causation chain analysis applies here at all in respect of the 4 emails. But if and it probably makes sense for me to deal with this point now, if it is found that the 4 emails were causatively potent, then the fraudster did intervene by manipulating those details, removing the bank details and inserting those of the Vietcombank account, and sending those communications on. That is the continuance of the fraud that had begun at a much earlier date. I certainly do submit that would be, if there is a chain of causation involving my client, that would breach it. And London Joint Stock Bank is going to be no answer to that at all, in circumstances where there isn't even a pleaded case that my client has breached the sort of duty that would be necessary to bring the parties within the principles in the Macmillan case. And so to that important extent, the question of the duty owed is fundamental. And there is no pleaded, it was said against me that there is a pleaded case that such a duty was owed and was breached, but in my submission there isn't. The only breach that is alleged is one of pure disclosure, as it were, under clause 14. It isn't, as I understand it, pleaded or said that there was a duty on my client, as distinct from Logix, to guard against the very eventuality that happened, i.e. the fraudster stealing the data. But even if there was, in my submission, the cause is still the fraudster's original intervention, the fraud from the beginning. Alternatively, the continuation of that fraud, the manipulation of the data, is an intervention and does break the chain of causation. Now, that is my alternative case. In my submission, the proper analysis of the causation case here is far simpler and doesn't involve this sort of analysis of a chain of causation on the facts here. The proper analysis in my submission is that of the judge, that the cause of the loss was the fraudster's fraud, which began a considerable period before the 4 emails that are relied on in paragraph 12A. Now, we haven't in fact looked today at those 4 emails, and my learned friend seems in that respect to be focusing almost if not exclusively on the emails on the 13th of August. Those were the 2 that were referred to before you, namely the sending of the signed SPA together with lists of LRUs, and the sending of invoices said to be in a form requested by the claimant in a telephone call with the defendant. So those are the 2 upon which my learned friend seems to be focusing. The other two are the sending of the draft SPAs together with lists of LRUs and the sending of registration information. Now, going back to the question of the width then of the of clause 14 and the proper interpretation of clause 14, I might in the time that I've got before the break perhaps deal with those two issues. So this is the third and fourth ground in the respondent's notice, which go to the question of wider interpretation. The analysis for which I contend is that the wide interpretation relied upon by my learned friend would drain the reference to commercially sensitive information in sub A of clause 14 of any meaning whatsoever. It would impose an obligation to treat as confidential information that was already in the public domain and is in no way confidential or commercially sensitive. And in my submission, that's not the purpose and is conspicuously not the purpose of this clause. The purpose of the clause is set by subparagraph A. That is the context. That is why this clause exists. And if we may just go to it, I have it in the supplemental bundle at tab 12, page 170. And in my submission, the purpose of the clause is really framed and set on its proper construction by A, that the letter of intent contains commercially sensitive information. What is clearly anticipated and meant by this clause is that the parties are engaging in a commercially sensitive negotiation in respect of the letter of intent, and they wish to protect from disclosure to third parties any loss or disclosure of information or documentation which is commercially sensitive. The counter-interpretation means any, and it must mean any at all, which in my submission cannot be the proper commercial construction of this clause. There's no real attempt to narrow or define that so that it captures some information or documentation, but not all. And as I understand my learned friend's case, it is maintained that absolutely everything constitutes a breach. Now, that of course rebounds on his own client, because his own client was occupied, and we'll see it briefly when we go to the documents, in precisely the same deception, sending information to the fraudster masquerading as the counterparty. So we do contend, and this is the third ground, that the protections arise and are intended to apply to commercially sensitive material. Now, of course, there will be some commercially sensitive material in the documents that go to and fro between the parties. But with respect, the commercial sensitivity of that information or documentation has absolutely nothing to do with how the fraud is carried out. The fraud is carried out through the sending and manipulating of both relatively unimportant in the course of the deal and more significant documents being sent in the course of the deal.
We're here in looking at, are we, judgment paragraph 96, which you challenge.
My lord, yes.
Yeah, just checking where this
Forgive
is
me, I
this is
should-
aimed
I
at. You
should-
say
yes.
that was wrong, and that the judge should have aligned herself with the reading that you're promoting now.
Yes. And that, of course, is for me the way through to the fourth ground.
Sorry, and 97. I beg your pardon. Yeah. So that she goes on specifically to deal with
I'm sorry, my lord, that's absolutely right. Yes.
96 to 97.
Yes.
Mr. Page suggested that you weren't challenging her finding about it, where she rejected your suggestion the clause only prohibits the disclosure of sensitive information that relates to the other party.
No, I haven't. To be fair to Mr. Page, in my respondent's notice, I haven't specifically said that I'm challenging that part of her ruling, but the narrower interpretation for which I contend is in the respondent's notice in respect of commercially sensitive
Your
information.
response notice is impartial as between the parties, as I read it.
I'm so sorry?
It's impartial as between the parties. That, and so at the moment, unless you tell us that you're saying it applies to one but not to the other, then that's where we rest.
Yes, and the one of the aspects there is that if one is looking at the wide interpretation of the contract, one of the many reasons it doesn't make sense commercially is that a party is in a position where if it said some information in a document is confidential because it's passing under the letter of intent, it becomes sort of cloaked with a confidentiality which it simply doesn't possess. And an example is the bank details or the serial numbers of the planes, the engines in question. When there's no suggestion that these things are inherently confidential or commercially sensitive in any way, but under the wide interpretation, they become so as a result of the operation of the clause. And that's one reason I submit it's not the right interpretation of the clause. But on the narrower one, the question then is of commercial sensitivity. So a party may have information belonging to itself, and it's then really within that party's control as to whether it considers that information to be commercially sensitive or not. And whether or not that material will be disclosed will depend on what is meant by commercially sensitive. But that will be far narrower in my submission than what my learned friend says, which is that anything and everything that passes is cloaked in confidentiality.
Is that a good moment? The clocks here are never particularly accurate.
If it's convenient for you, my lord, yes, absolutely.
Very well. Now, Mr. Page, I know you want to do a little bit of thinking and you don't have to get it done at the expense of refreshment. But if you wanted another 10 minutes on the lunch hour, you're perfectly welcome to it.
I think I don't know how long Miss Coulter thinks the submission is going to last. I don't want to cause a problem at the end of the day.
Well, I think, Ms. Coulter, we're optimistic we're going to be well within our time
I would have thought so.
time estimate.
I would appreciate, my
All
lord.
right.
thank you
Well,
very
shall
much.
we start again at 10 past to allow for that? But if if there are researches which you're not able to do at this point, we're perfectly happy to have modest written follow-up after the hearing if that's more suitable. But for now, thank you very much. 10 past 2.
Advisor favourable?